Chapter 3, Arrest, Search, and Seizure. Part 1, the Exclusionary Rule. The Fourth Amendment to the United States Constitution reads, "The people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but on probable cause, supported by oath or affirmation, and particularly describing the place to be searched and person or things to be seized." The amendment says nothing about how it is to be enforced, a matter which has been the subject of vigorous debate over a good many years. Most of this debate has focused upon the wisdom of and constitutional necessity for the so-called exclusionary rule, whereunder evidence obtained in violation of the Fourth Amendment is ordinarily admissible in a trial court. Criminal trial. This exclusionary rule has existed in the federal criminal justice system for nearly 75 years, but it has been at the state level not nearly as long. In the first two cases in this section, Wolf v. Colorado and Mapp v. Ohio, we see the court first rejecting and then accepting the notion that this exclusionary rule is constitutionally required in the state courts. Mapp by no means ended the argument, though in more recent years, much of the debate has centered upon the proper scope of the exclusionary rule. If all the Supreme Court often indicated a primary purpose of the rule is deterrence of the police, then precisely when is exclusion appropriate in the sense that it will likely have such a deterrent effect? The court gives some answers to this question in United States v. Leon, Hudson v. Michigan, and Herring v. United States, the final three cases in this section. So I'm going to start with Wolf v. Colorado and hope to get through it. It's a 1949 case. Justice Frankfurter delivered the opinion of the court. The precise question for consideration is this: does a conviction by a state court for a state offense deny the due process of law required by the 14th Amendment solely because evidence that was admitted at the trial was obtained under circumstances which would have rendered it inadmissible in a prosecution for violation of a federal law in the court of the United States because they're deemed to be an infraction of the Fourth Amendment? So this sounds like you're trying to apply a federal right to the states. Interesting. We're not past that yet. So the security of one's privacy against arbitrary intrusion by the police, which is at the core of the Fourth Amendment, is basic to a free society. It is therefore implicit in the concept of ordered liberty and such enforceable against the states through the due process clause, ... of the 14th Amendment. And accordingly, we have no hesitation in saying that were a state affirmatively to sanction such police incursion into privacy, it would run counter to the guarantee of the 14th Amendment. But the ways of enforcing such a basic right raise questions of a different order. How such arbitrary conduct should be checked, what remedies against it should be afforded, the means by which the right should be made effective, are all questions that are not to be so dogmatically answered as to preclude the varying solutions which spring from an allowable range of judgment on issues not susceptible of quantitative solution. In Weeks v. United States in 1914, this court held that in a federal prosecution, the Fourth Amendment barred the use of evidence secured through an illegal search and seizure. This ruling was not derived from the implicit requirements of the Fourth Amendment. It was not based on legislation expressing congressional policy and the enforcement of the Constitution. The decision was a matter of judicial implication. Since then, it has been frequently applied, and we stoutly adhere to it. But the immediate question is whether the basic right to protection against arbitrary intrusion by the police demands the exclusion of logically relevant evidence obtained by an unreasonable search and seizure because in the federal prosecution for a federal crime it would be excluded. As a matter of inherent reason, one would suppose this to be an issue as to which men with complete devotion to the protection of the right of privacy might have different answers. When we find that, in fact, most of the English-speaking world does not regard as vital to such protection the exclusion of evidence thus obtained, we must hesitate to treat this remedy as an essential ingredient of the right. The contrariety of views of the states is particularly impressive in view of the careful reconsideration which they have given the problem in light of the Weeks decision. As of today, 30 states reject the Weeks doctrine. 17 states are in agreement with it. Of 10 jurisdictions within the United Kingdom and the British Commonwealth of Nations which have passed on the question, none has held evidence obtained by a legal search and seizure admissible. Inadmissible. The jurisdictions which have rejected the Weeks doctrine have not left the right to privacy without other means of protection. Indeed, the exclusion of evidence is a remedy which directly serves only to protect those upon whose person or premises something incriminating has been found. We cannot, therefore, regard it as a departure from basic standards to remand such persons together with those who emerge scatheless from a search to the remedies of private action and such protection as the internal discipline of the police under the eyes of an alert public opinion may afford. Granting that in practice the exclusion of evidence may be an effective way of deterring unreasonable searches, it is now for this court to condemn as falling below the minimal standards assured by the Due Process Clause the state's reliance upon other means which, if consistently enforced, would be equally effective. There are, moreover, reasons for excluding evidence unreasonably obtained by the federal police which are less compelling in the case of police under state or local authority. The public opinion of a community can far more effectively be exerted against oppressive conduct on the part of police directly responsible to the community itself than can local opinions, sporadically aroused, be brought to bear the remote authority pervasively exerted throughout the country. We hold, therefore, that in a prosecution in the state court for a state crime, the 14th Amendment does not forbid the admission of evidence obtained by an unreasonable search and seizure. Because it's a local, it requires local oversight, local execution by the executive branch. So Justice Black concurs, and Justice Murphy and Justice Rutledge dissent. And Douglas dissents. And 3 dissenting, so we probably have the majority opinion probably has another couple people concurring. So Justice Black concurs, saying, I agree with what appears to be a plain implication of the court's opinion that the federal exclusionary rule is not a command of the Fourth Amendment, but is a judicially created rule of evidence which Congress might negate. Justice Murphy, with whom Justice Rutledge joins, dissenting, there is but one alternative to the rule of exclusion, that is no sanction at all. Little need be said concerning the possibilities of criminal prosecution. Self-scrutiny is a lofty ideal, but its exaltation reaches new heights if we expect a district attorney to prosecute himself for the associates for well-meaning violations of the search and seizure clause during a raid the district attorney or his associates have ordered. But there is an appealing ring in another alternative. A trespass action for damages is a venerable means of securing reparation for unauthorized invasion of home. Why not put the old writ to a new use? When the court cites cases permitting the action, the remedy seems complete. But what an illusory remedy this is. If by remedy we mean a positive deterrent to police and prosecutors tempted to violate the Fourth Amendment, the appealing ring softens when we recall that in a trespass action, the measure of damages is simply the extent of the injury to physical property. If the officer searches with care, he can avoid all but nominal damages. A penny or a dollar. Are punitive damages possible? Perhaps. But a few states permit none, whatever the circumstances. In those that do, the plaintiff must show the real ill will or malice of the defendant, and surely it is not unreasonable to assume that one in honest pursuit of crime bears no malice towards the search victim. If that burden is carried, recovery may yet be defeated by the rule that there must be physical damages before punitive damages may be awarded. In addition, some states limit punitive damages to the actual expenses of litigation. Even assuming the ill will of the officer, his reasonable grounds for belief that the home be searched harbored evidence of crime is admissible in mitigation of punitive damages. The bad reputation of the plaintiff is likewise admissible. If the evidence seized was actually used at trial, that fact has been held a complete justification of the search and a defense against the trespass action. And even if the plaintiff hurdles all these obstacles and gains a substantial verdict, the individual officer's finances may well make the judgment useless for the municipality, of course, is not liable without its consent. It is surprising that there is so little in the books concerning trespass actions for violation of the search and seizure clause. Justice Douglas is dissenting. I agree with Justice Murphy that in absence of an exclusionary rule of evidence, the amendment would have no effective sanction. So Mapp v. Ohio is the next case, and if it is equally short, this is a 1961 case, so around the same time range. Justice Clark delivered the opinion of the court. In May 23, 1953, 3 police officers arrived at appellant's residence in that city pursuant to information that a person was hiding out in a home who was wanted for questioning in connection with the recent bombing, and that there was a large amount of police paraphernalia being hidden in the home. Miss Mapp and her daughter, by a former marriage, lived on the top floor of a 2-family dwelling. Upon their arrival at the house, the officers knocked on the door and demanded entrance, but appellant, after telephoning her attorney, refused to admit them without a search warrant. The officers again sought entrance some 3 hours later, when 4 or more additional officers arrived on the scene. When Miss Mapp did not come to the door immediately, at least one of the several doors of the house was forcibly opened, and the policemen gained admittance. Meanwhile, Miss Mapp's attorney arrived, but officers, having secured their own entry and continuing in their defiance of the law, would permit him neither to see Miss Mapp nor to enter the house. When the officers broke into the hall, Miss Mapp demanded to see a search warrant. A paper claimed to be a warrant was held up by the officer. She grabbed the warrant and placed it in her bosom. A struggle ensued in which the officers recovered the piece of paper, as a result of which they handcuffed appellant because she had been belligerent and resisting their official rescue of the warrant from her person. Appellant in handcuffs was then forcibly taken upstairs to her bedroom, where the officers searched a dresser, a chest of drawers, a closet, and some suitcases. Then the search spread to the rest of the second floor. The basement of the building and a trunk found therein were also searched. The obscene materials for possession of which she was ultimately convicted were discovered in the course of that widespread search. At the trial, no search warrant was produced by the prosecution, nor was the failure to produce one explained or accounted for. At best, as the Ohio Supreme Court, which affirmed the conviction, expressed it. There is, in the record, considerable doubt as to whether there ever was any warrant for the search of defendant's home. The state says that even if the search were made without authority or otherwise unreasonably, it is not prevented from using the unconstitutionality seized evidence at trial, citing Wolf versus Colorado. On this appeal, it is urged once again that we review that holding. So those are the facts. And the issue just came up. So the court in Wolf first stated that the contrariety of views of the states on the adoption of the exclusionary rule of weeks was particularly impressive. While in 1949, prior to the Wolf case, almost 2/3 of the states were opposed to use of the exclusionary rule. Contrariety. Despite the Wolf case, more than half of those since passing upon it by their own legislative or judicial decision have wholly or partly adopted or adhered to the Weeks rule. Significantly, among those now following this rule is California, which, according to its highest court, was compelled to reach that conclusion because other remedies have completely failed to secure compliance with constitutional provisions. In addition, or in connection with this California case, we note that the second basis elaborated in Wolf in support of its failure to enforce the exclusionary doctrine against the states was that other means of protection have been afforded. The right to privacy, the experience of California, end quote. The experience of California that such other remedies have been worthless and futile is buttressed by the experience of the other states. Likewise, time has set its face against what Wolf called the weighty testimony of People verse DeFore. Their justice, then Judge Cardozo in 1926, rejected adoption of the Weeks exclusionary rule in New York. He said that the federal rule, as it stands, is either too strict or too lax. However, the force of that reasoning has been largely vitiated by later decisions of this court. These include the recent discarding of the silver platter doctrine. So when you take notes, like I am writing down Weeks doctrine, because that's what's being challenged, kind of, and then Elkins versus United States is where the silver platter doctrine comes from. Silver platter. The relaxation of the formally strict requirements as to standing to challenge the use of evidence thus seized. And finally, the formulation of the method to prevent state use of evidence unconstitutionally seized by federal agents in Ray versus United States. It therefore plainly appears that the factual considerations supporting the failure of the Wolf Court to include the Weeks exclusionary rule when it recognized the enforceability of the right to privacy against the states in 1949, while not basically relevant to the constitutional consideration, could not, in any analysis, now be deemed controlling. Today, we once again examine Wolf's constitutional documentation of the right to privacy free from unreasonable state intrusion, and after its dozen years on our books, are led by it to close the only courtroom door remaining open to evidence secured by official lawlessness and flagrant abuse of that basic right reserved to all persons as a specific guarantee against that very same unlawful conduct. We hold that all evidence obtained by searches and seizures in violation of the Constitution is, by that same authority, inadmissible in state court. So this is a new holding. Since the Fourth Amendment's right to privacy has been declared enforceable against the states through the Due Process Clause of the 14th, it is enforceable against them by the same sanction of exclusion as is used against the federal government. Were it otherwise, then just as without the Weeks rule, the assurance against unreasonable federal searches and seizures would be a form of words, valueless and undeserving of mention in a perpetual charter of inestimable human liberties. So too, without the rule, the freedom from state invasions of privacy would be so ephemeral, and so neatly severed from its conceptual nexus with the freedom from the brutish means of coercing evidence as not to merit the court's high regard as a freedom implicit in the concept of ordered liberty. In extending the substantive protections of due process to all constitutionally unreasonable searches, state and federal, it was logically and constitutionally necessary that the exclusion doctrine, an essential part of the right to privacy, be also insisted upon as an essential ingredient of the right newly recognized by the Wolf case. In short, the admission of the new constitutional right by Wolf could not consistently tolerate denial of its most important constitutional privilege, namely the exclusion of the evidence which an accused had been forced to give by reason of the unlawful seizure. To hold otherwise is to grant the right, but in reality withhold its privilege and enjoyment. Only last year, the court itself recognized that the purpose of the exclusionary rule is to deter constitutional guarantee in the only effective available way by removing the incentive to disregard it, end quote. Indeed, we are aware of no restraint similar to that rejected today, conditioning the enforcement of any other basic constitutional right, the right to privacy, no less important than any other right carefully and particularly reserved to the people, would stand in marked contrast to other rights declared as basic to a free society. Noting, and nothing could be more certain than that when a coerced confession is involved, the relevant rules of evidence are overridden without regard to the incident of such conduct by the police, slight or frequent. Why should not the same rule apply to what is tantamount to coerced testimony by way of unconstitutional seizure of goods, papers, effects, documents, etc.? We find that as to the federal government of the Fourth and Fifth Amendments, and as to the states, the freedom from unconscionable invasions of privacy and the freedom from convictions based upon coerced confessions do enjoy an intimate relation in their perpetuation of principles of humanity and civil liberty. They express supplementing phases of the same constitutional purpose to maintain inviolate large areas of personal privacy. The philosophy of each amendment and of each freedom is complementary to, although not dependent upon, that of the other in the sphere of influence, the very least that together they assure in either sphere that no man is to be convicted on unconstitutional evidence. Moreover, our holding is not the logical dictate of our prior cases, but it also makes very good sense. There is no war between the Constitution and common sense. Presently, the federal prosecutor may make no use of evidence legally seized, but a state's attorney across the street may, although he supposedly is operating under the enforceable prohibitions of the same amendment. Thus, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal Constitution, which it is bound to uphold. There are those who say, as did Justice, then Judge Cardoso, that under our constitutional exclusionary doctrine, the criminal is to go free because the constable has blundered. People versus DeFore. In some cases, this will undoubtedly be the result. But as was said in Elkins, there is another consideration: the imperative of judicial integrity. The criminal goes free if he must, but it is the law that sets him free. Nothing can destroy a government more quickly than its failure to observe its own laws, or worse, its disregard of the charter of its own existence, as Mr. Justice Brandeis dissenting said in Olmsted versus United States, 1928. Our government is the potent and omnipresent teacher, for good or for ill. It teaches the whole people by its example. The government becomes a lawbreaker. It breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. Nor can it lightly be assumed that, as a practical matter, adoption of the exclusionary rule fetters law enforcement. Only last year, this court expressly considered that contention and found that pragmatic evidence of a sort to the contrary was not wanting. The court noted that the federal courts themselves have operated under the exclusionary rule of weeks for almost half a century. Yet it has not been suggested either that the Federal Bureau of Investigations has thereby been rendered ineffective, or that the administration of criminal justice in the federal courts has thereby been disrupted. Moreover, the experience of the states is impressive. The movement towards the rule of exclusion has been halted, but seemingly inexorable. The ignorant shortcut to conviction left open by the state tends to destroy the entire system of constitutional restraints on which the liberties of the people rest. Having once recognized that the right to privacy embodied in the Fourth Amendment is enforceable against the states, and that the right to be secure against rude invasions of privacy by state officers, is therefore constitutional in origin, we can no longer permit that right to remain an empty promise, because it is enforceable in the same manner and to like effect as other basic rights secured by the Due Process Clause. We can no longer permit it to be revocable at the whim of any police officer who, in the name of law enforcement itself, chooses to suspend its enjoyment. Our decision, founded on reason and truth, gives to the individual no more than that which the Constitution guarantees him, to the police officer no less than that to which law enforcement is entitled, and to the courts that judicial integrity is so necessary in the true administration of justice. Reversed and remanded. Justice Black concurring: I am still not persuaded that the Fourth Amendment standing alone would be enough to bar the introduction into evidence against an accused of papers and effects seized from him in violation of its commands. For the Fourth Amendment does not itself contain any provision expressly precluding the use of such evidence, and I am extremely doubtful that such a provision would properly be inferred from nothing more than the basic command against unreasonable searches and seizures. Reflection on the problem, however, in the light of cases coming before the court since Wolf, has led me to conclude that when the Fourth Amendment's ban against unreasonable searches and seizures is considered together with the Fifth Amendment's ban against compelled self-incrimination, the constitutional basis emerges, which not only justifies but actually requires the exclusionary rule. Justice Douglas concurring: I believe that this is an appropriate case in which to put an end to the asymmetry which Wolf imported into the law. Memorandum of Justice Stewart: I express no view as to the merits of the constitutional issue which the court today decides. Justice Harlan and Justice Frankfurter and Justice Whittaker joined dissenting. Their dissenting is kind of long, but I could get through it anyway, so I would not impose upon, but this will be where I stop after I read this. I would not impose upon the states this federal exclusionary remedy. The reasons given by the majority for now suddenly turning its back on Wolf seem to me notably unconvincing. First, it is said that the factual grounds upon which Wolf was based have since changed, and that more states now follow the Weeks exclusionary rule than was so at the time Wolf was decided. While that is true, a recent survey indicates that a present one half of the states still adhere to the common law non-exclusionary rule, and one, Maryland, retains the rule as to felonies. But in any case, surely all of this is besides the point, as the majority itself indeed seems to recognize. Our concern here, as it was in Wolf, is not with the desirability of that rule, but only with the question whether the states are constitutionally free to follow it or not, as they may themselves determine. And the relevance of the disparity of views among the states on this point lies simply in the fact that the judgment involved is a debatable one. Moreover, the very fact on which the majority relies, instead of lending support to what is now being done, points away from the need of replacing voluntary state action with federal compulsion. The preservation and a proper balance between state and federal responsibility in the administration of criminal justice demands patience on the part of those who might like to see things move faster among the states in this respect. Problems of criminal law enforcement vary widely from state to state. One state, in considering the totality of the legal picture, may conclude that the need for embracing the Weeks rule is pressing because other remedies are unavailable or inadequate to secure compliance with the substantive constitutional principle involved. Another, though equally solicitous of constitutional rights, may choose to pursue one purpose at a time, allowing all evidence relevant to guilt to be brought into a criminal trial and dealing with constitutional infractions by other means. Still another may consider the exclusionary rule too rough and ready a remedy in that it reaches only constitutional intrusions which eventuate in criminal prosecution of the victims. Further, a state may, after experimenting with the Weeks rule for a time, may, because of unsatisfactory experience with it, decide to revert to a non-exclusionary rule, and so on. For us to question remains, as it has always been, one of the state power and not one of passing judgment on the wisdom of one state course or another. In my view, this court should continue to forbear from fettering the states with an adamant rule which may embarrass them in coping with their own peculiar problems in law enforcement. Our rule in promulgating the Weeks rule and its extensions was quite a different one than it is here. There, in implementing the Fourth Amendment, we occupied the position of a tribunal having the ultimate responsibility for developing the standards and procedures of judicial administration within the judicial system over which it presides. Here we review state procedures whose measure is to be taken not against the specific substantive commands of the Fourth Amendment, but under the flexible contours of the Due Process Clause. I do not believe that the 14th Amendment empowers this court to mold state remedies, effectuating the right to freedom from arbitrary intrusion by the police to suit its own notions of how things should be done. Finally, it is said that the overruling of Wolf is supported by the established doctrine that the admission of evidence of an involuntary confession renders a state conviction constitutionally invalid, since such a confession may often be entirely reliable. And therefore of the greatest relevance to the issue of the trial. The argument continues. This doctrine is ample warrant in precedent, that the way evidence was attained and not just its relevance is constitutionally significant to the fairness of a trial. I believe this analogy is not a true one. The coerced confession rule is certainly not a rule that any legally obtained statements may not be used in evidence. I would suppose that a statement which is procured during a period of illegal detention is, as much as unlawfully seized evidence illegally obtained, but this court has consistently refused to reverse state convictions resting on such statements. The point then must be that in requiring exclusion of an involuntary statement of the accused, we are concerned not with the appropriate remedy for what police have done, but with something which is regarded as going to the heart of our concepts of fairness in judicial procedure. The operative assumption of our procedural system is that ours is the accusatorial as opposed to the inquisitorial system. The pressures brought to bear against the accused, leading to a confession, unlike an unconstitutional violation of privacy, do not, apart from the use of the confession at trial, necessarily involve independent constitutional violations. What is crucial is that the trial defense to which an accused is entitled should not be rendered an empty formality by reason of statements wrung from him, for then a prisoner has been made the deluded instrument of his own conviction. Oh, I like that quote. That this is a procedural right and that its violation occurs at the time his improperly obtained statement is admitted at trial is manifest. Thus, and not the disciplining of police as with illegally seized evidence is sure to be true for excluding the statement of the accused which was unconstitutionally obtained. In sum, I think the coerced confession analogy works strongly against what the court does today.